Chaitanya Murthy Konkiapudi. My people call me CK in Australia. So I've been in Australia for almost 12 years now. And I have been actually like working as head of data for Chemist Warehouse, which is one of the major retail pharmacy companies in Australia. So we are actually like an Australia-based company, but now we have expanded and we have actually branches in New Zealand, China, Ireland, and we are close to opening a store in Dubai, and we are actually like moving big time in the Europe. So we are actually like moving towards more of a global footprint company.
Sorry, if you're not going to speak, I request you to go on mute, please. Sorry.
So regarding my experience, I have close to 20 years of experience in diversified fields within IT. I did my master's in technology in IT, and then I actually worked in India, and I worked for British Telecom in UK, then moved to Bell Telecom in Canada before I settled down in Australia. And Australia is a country where I spent most of my career. And now I lead a team of data and AI within Chemist Warehouse. And I have a good amount of data analysts and data engineers. And we also like to do a few things. We recently started engaging on the AI products. So we built our own AI products. So as a part of this, we share shared responsibility with our cybersecurity team with respect to data protection, data privacy, because it's a shared responsibility between information security and data teams. So that's what we actually like do, and that's about me. And in my free time, I'm an avid yoga practitioner. So I'm associated with Vasudeva Kriya Yoga, which is in Australia. So I actually like practice yoga and also teach yoga in my free time. So, and I have been kind of ambassador for yoga within my community in Australia. So that's about me. Now, coming to the topic, what we actually like here for navigating Australian privacy law. See, privacy law, as everyone actually like can see that every country actually as it's now is coming up with its own privacy law. And it is based on GDPR, which is the fundamental baseline version, what people actually like have. And then every country started actually navigating its own way of doing things. So, and India is also coming up with TPDT, that's a new thing. But if we focus on the webinar topic, which is the navigating the Australian privacy law, what I want to actually like do is I want to actually like first introduce a few things on what is the legislation, what is the key principles, what Australian privacy law talks about. Then we move on. How do we actually like protect their personal data with respect to first PII and sensitive data? Then we actually like move towards APP, what is Australian privacy principles. There are 13 Australian principles which we actually like have to follow, a company needs to follow if they want to do private impact assessment. So we'll focus on that. Then we'll try to actually like move towards what is international transfers. What happens if company actually transfers the data of the customers who are in Australia, but they are actually the data is located elsewhere. How do we actually like what principles can actually like apply? Then we move towards probably I also put up a case study which in 2018, there's an Australian retailer which actually went for a data breach. So how did actually like, what is the role of the Office of Australian Information Commissioner here, which is a kind of a regulatory body, and how did actually like it mitigate the risk, and what are the repercussions of having a data breach? And then we'll actually move on to what are the best practices, what the company had to apply, and then we'll actually close the session. So that is loosely the kind of the key takeaways, what I want to actually like do it. And then we'll also have a question and answer session. But feel free if you feel that like you want to actually like have a pressing question which you want to ask, please feel free to actually like ask. But if I start this session, the Australian, like any other country, and actually like is a very robust, and we protect the information through a mix of federal, because Australia is a federal country, like we have a federal government based in Canberra. But at the same time, every state, states actually can have their own laws. And also we have territories, like how we have union territories in India. Similarly, we have two territories, which is ACT, Australian Capital Territory, and Northern Territory. which actually like can have its own law. So, but fundamentally, there will be a federal privacy law, what we call it as a Privacy Act, which actually like Australia use or the state actually uses as a baseline for its information protection regime. So,
Okay.
and then now if I move on, as I told you, the key takeaway for this webinar, I want to concentrate on what is the key legislation and regulatory bodies in Australia and how we actually like handle collecting and handling personal information, which is critical for any company, including retail. Retail is a much more exposed area because, and especially since I work in retail pharmacy, we actually like hold sometimes the customer prescription. So what is the data minimization principle? How do you actually like handle the finance data versus scripting data? When I say scripting, the prescription data, and how do you handle customer PI data? So that's what we talk about, collecting and handling personal information. What is meant by NDB, what we call it as noticeable data breaches. So there's a principle within the Privacy Act, which actually talks about it. So that's what we talk about, the breach notification. Then I spoke about how does cross-border data transfer. So that means if a customer is located physically in Australia, but the data what he or she has given is actually being sent elsewhere. So then how do we actually like handle that? So that we talk about cross-border data transfer. Then we have what are the privacy policies and procedures. Then we talk about individual rights and access requests. What does the customer actually like have like a kind of a, because privacy is becoming now a fundamental right. It is no more option. Privacy is a fundamental right in every country. Then we talk about compliance and enforcement. I did mention about OIAC, which is Office of Information, Office of the Commissioner of Information Security. So that is where we actually like have an enforcement authority in Australia. Then what are the best practices the companies can actually follow? So the regulatory body has given the best practices. Now companies can customize it according to their requirements and objectives, but it has to align to that particular best practices. So that we talk about. Then what is the recap? I'll recap in one pager what would be the Australian privacy law talks about. Then we pick up a case study, and then we actually will go through what did the case study actually like the company actually went through, and how did they come out, what kind of like reputation they actually like lost, and what is the impact of the share prices. So there's a lot of deeper, that's why as we dive deeper we'll understand it. So I'll move on. So the privacy regulation in Australia, so we are actually like bound by Privacy Act 1988. So now, as I say, things are changing because recently there's a law which is being discussed in the Parliament of Australia, where they might actually like make it more stringent, this Privacy Act. They want to bring a new Privacy Act 2024, which apparently it is still not published yet, but once we publish it, probably they will actually like add more. But still, we actually like get that officialized. We do have a Privacy Act 1998, which is primary legislation governing personal information handling in Australia, which includes the 13 Australian privacy principles. So we'll go through the 13 privacy principles as we actually like go, but I don't want to make it more theoretical, but I want to actually like give you a kind of a gist of how this Privacy Act actually goes through. Then you actually like have, then as I told you, we have a regulatory body in Office of the Australian Information Commissioner, which is an independent national regulator enforcing the Privacy Act, providing guidance to businesses, Australian businesses, and also like Australian businesses which are set up outside as well, like in New Zealand. So say, for example, Chemist Warehouse is located in New Zealand. We do have to actually like go with the act of what this regulatory body has actually like set up. So we'll pick up the best practices and we'll build a baseline over it. So, and then the thing is state privacy laws. As I told you, every state in Australia, it is a federal structure. What it means is the central government, actually the federal government actually has a structure. Now, the state government can take that structure and tweak it according to the state laws. So every state, Victoria, New South Wales, Queensland, Western Australia, Northern Territory, ACT, Tasmania, they have their own laws. So we are bound by the state laws first. So that's the reason the additional privacy laws in some states can be different, especially in health. Because I work in pharmacy, for example, we have a concept called OTC, over the counter. So say Panadol, which is Crocin loosely in India. So in Crocin in India, you can actually go and you can ask like a pharmacist within the medical store to say, I need Crocin. Nowadays, you can actually pick up Crocin even from any of your provision stores. But in Australia, different states have different laws there. So in Victoria, it is allowed to actually go and pick that particular Panadol, but in Queensland, you need to ask the pharmacist. So there are certain rules which are different for each state. That is dictated by the state government. That is what the state privacy law talks about here. And how does the information of the customer is stored? And again, it is bound by the state. Queensland has a different legislation when compared to South Australia. Out of all the states, South Australia is a little stringent, but Victoria and New South Wales are also stringent in a way, but they actually have different laws complying to the PII versus the health information data.
Yeah, but Panadol is just a paracetamol. So even paracetamol
Yes.
has got, and
Yeah,
because we find that you have been in BT, right? So even in Tesco, you get this Panadol everywhere in UK. So, but in Australia, it's not that way. There's a restriction.
Different states have different things because there is a concept of overweight abuse of the medication. So people can actually take it. So that's the reason different states, say for example, Queensland, we do have OTC counters to actually legislate that. But in Victoria, you can actually pick up as you just said. So you can actually go there and just pick it up. So different states have different laws, even for the vaccinations, different states. Suppose say Victoria, you can actually people can be trained, especially during COVID, many people got trained to actually administer vaccines because of the shortage of resources, health resources. But if you go to other states, compulsory a nurse or a doctor has to administer that. Now they extended that to a pharmacist. So, but there's a different laws which are abiding by it.
Okay, yeah, thanks.
Yeah. Then you actually have a privacy principles, which I was talking about, the APP, which is Australian Privacy Principle. There are 13 Australian APPs, which we call, and every company or a business which are binding by the APP are called APP entities. Please understand the term entities. Entities are nothing but the organizations or the legal entities which are actually adapting the APPs, which are Australian Privacy Principles. I've actually cut short. I've just summarized it in such a way that people can understand. So the key principles for handling the personal information in any retail setting or a bank setting or any business, I'm just putting retail setting because I'm from a retail company. So is transparency. So retailers, especially our stores, our website, we have to explain the customer how we collect the data and how we are actually using the data, and also how do we protect this information for the customers. So this is very important for the customer to understand that we have to publicize. If you go to Chemiswara store, and you can always ask the pharmacist how you are actually collecting this information and what you're doing with this information. So there is every transparency what we actually have, and that is actually abided by an Australian privacy principle. So that is one of the Australian privacy principle, which is APP1, which talks about transparency. Then we do have anonymity. That means we offer customers, especially for those customers who actually have administration. For example, a customer who is taking, say, Viagra, he or she doesn't want to even intimate their partners. So in that particular thing, we do offer the customers the option to browse and shop anonymously without providing personal details. On our website, if you have actually gone to our website, we do sell adult and sex toys, but we don't want to actually expose those customers who browse those pages. So this is a kind of anonymity what we offer to customers to browse, and also when they actually give the information, they are rest assured that it is actually anonymous. So we can identify the customer only if need be, but we offer that particular option, and that is a part of guided by the fundamental right as what we actually have in APP2. Then we have minimized collection. So as we actually have the regulatory body encourages all the Australian businesses, including ours, to actually only collect the necessary personal information for specific purposes, like say loyalty programs, or you actually have a prescription data. Now we have e-prescriptions. I think people who actually have been in Western countries, they know what is meant by e-prescription. So the doctor actually prescribes something, and before the patient actually walks into the store, the prescription is actually available to the pharmacist through different means of digital channels. So now that is a very sensitive data because it is dealing with customer prescriptions. So in this particular thing, we do actually encourage that we follow the data minimization principle. What it means is we only store what is needed. We don't actually use the data for any personalization of the customer, because say, for example, CK is using Viagra. I don't want to actually advertise to CK saying that, hey, you have been using Viagra. That means you are actually so I can't actually advertise something else for CK. So that is a breach of privacy. So that is what we actually like to do, is minimized collection. So that is the data minimization principle in GDPR that is actually aligned to this. If you have actually, like if I'm just going through, you see that most of the principles are aligned to GDPR. That is a baseline what we actually like have. So, but Australia has taken best practice from Singapore, Australia, and I've been reading the Indian like GDPR, like equivalent of GDPR, DPDT. It's mostly the same.
Much all time.
So then you actually like have security measures. So now you collect the data. How do you ensure that you have a robust security measures to protect this particular information for any misuse or authorized access? So we do have different ways to put the measures. You can put like identity platforms like Okta or Azure AD to make it like that. There's a technology solutions to make it better. But at the same time, the consistent training for employees, the consistent training for all the stakeholders who are handling this particular data is where we actually like, that is a fundamental thing, because that is, we feel that human is the first firewall. If human is breached, the person who's handling that particular data is breached, then it's easy to actually get hold of the personal data. So that is where we actually like the Australian government or the regulatory body has a very stringent security, data security measures, which we need to adapt if we are actually like handling after some the customer data or any data which is termed as sensitive data, including the health data. Then we do have so this is about what are the regulatory body key principles and who are the regulatory bodies and what is the concept of APP, which is Australian the privacy principles. I'll go through the 13 APPs as we in the key takeaway slide as we actually like go. That will give you a summary. So now the important thing is collecting and handling personal information. So this is how do we handle that is to ensure that how much of an individual can be identifiable. So that means the personal information, what we actually define. You say the name, first name, last name, the date of birth, the gender, then you actually have the prescriptions or the kind of likes and dislikes, the political views. Everything can be termed as personal and sensitive information. And how do we actually like handle? So there are certain rules for it. So we have to like the requirement for the lawful and transparent collection of personal data, as we talked about APPs, are always actually like a kind of a paramount when we do handle personal data. So, and then we do need to have the very clear and precise privacy notices for data collection practices. So the stores, or I'm talking about again for Chemist Warehouse, our stores, our channels where we actually interact with customers or we handle PI data, including customer service, we do have a clear and accessible privacy notices. We do actually allow the customers to actually like know what information is being stored, how it is being stored, and where it is being stored. And if the customer chooses that, if I want to we want a valid consent before we expose the customer, say a customer calls our call center, he wants to know or she wants to know about an order which he actually placed, which contained prescriptions. Definitely, we need to have a valid consent, because we don't know how do we actually like ensure that the customer who is actually calling us is a real customer who's asking the details. So in this case, we do have certain ways to actually like have like identifying the customers. Then we do actually need to get the valid consent when collecting sensitive information, say credit card information, because we have a concept called phone ordering. So in phone ordering, we do actually like allow customers to actually tell some personal details. So how do you actually like get a consent before you get those details? So that is the kind of imparting of the staff training what we have. Then what are the best practices we are actually like we get from the regulatory bodies so that we can do a responsible collection and handling of personal information. So this is about, again, this is a kind of a framework what we have. We have to, it is the best practices what we actually like follow. Again, we can, on top of it, we can put our own customizations to ensure that we collect and handle personal information. There will be exceptions. That has to be discussed with the data privacy officer, data protection officer, along with the cybersecurity team to ensure that we are actually adhering to the APP principles. Now, if I move on to...
just a question. I think Balaji has got a question for you. Balaji, can you put it up?
No, sorry, I was asking about the consent only. He talked about the privacy notices, right? The appropriate consent should be received from the users before we process any data privacy processes. Okay, got it. Thank you.
Thank you. So now we speak about data security and NDBs. NDBs are notifiable data breaches. So this situation occurs when, say, if a company actually had a data breach, so where they actually had some kind of breach on their customer data or anything related to sensitive information related to prescriptions or anything related to which is personal or sensitive, which is categorized. So then what are the safeguards businesses need to take? How do they notify the regulatory bodies, and how do they respond to the data breach, and how do they develop a kind of a response plan? So that is what this slide talks about. If I just go into deeper, the security safeguards. So businesses, including any businesses in Australia, including Chemist Warehouse, we need to protect customer data because we handle customer data for any misuse, loss, unauthorized access. So what are the measures we need to actually take to ensure that we have data security? As you know, encryption at rest, encryption in transit, access controls, role-based access. We do have to follow least access principle. What it actually is a zero trust policy. And then we do have have to put a lot of emphasis on staff training. As I told you, the employee is the human firewall for any businesses to be safeguarded. Because if employees, whatever important, like we actually have this fancy, sophisticated technologies which can actually protect the data, but ultimately the users or the employees are not trained to handle the customer data, as Balaji was actually highlighting. How do we get a consent from the customer? How do you talk to a customer when it actually when people actually call us to the call center? How do you deal with customers at the store? How do you deal with customers at a different channel, what we actually have? So the staff training is very important, and that too we need to actually mitigate. How do we simplify data security best practices? So we do actually have a training platform within Chemist Warehouse, for example, where we do have cybersecurity awareness training for every month. We do actually do data security trainings. So we actually explain the purpose of in simple terms, in short videos, and try to actually give them some quizzes to engage them. So in that way, we actually engage the staff to ensure that they are actually protected, and they actually have a clear pathway to actually go into. We also do mock data, kind of a malware attacks. We actually want to ensure that the employees actually know what to do if a situation actually arises. So that is what we have started adapting to. So that is the security safeguards slide we actually talk about. If I move on, as I told you, the notifiable data breaches, which is a scheme which is within the regulatory body where businesses must promptly notify. Say, for example, one of the company actually got data breached, and how the company, when it actually gets data breached, who is responsible to notify the individuals in and the regulatory body of the data breach likely to cause, what kind of harm it actually causes. So that is what we need to actually notify. So this is a part of the data protection principles. What we actually have is that the Australian government, through this APPs and NDBs, they actually train the businesses on how do we actually approach them if there is a notifiable data breach. And of late in Australia, you might have seen Optus, one of our big telecom providers, and then we actually have one of our insurance companies actually got a data breach, and then they actually had some kind of criticism on they were actually unable to employ or notify the affected individuals. And in this case, affected individual, I'm a customer of Optus, for example, I should be notified of this particular data breach because my sensitive information got actually hacked. And similarly, OIAC, which is the regulatory body. So there's a response plan for it. That is what we're actually going through, is how do you build that response plan? So this is where the Australian government, through that regulatory body, can actually work with the businesses to actually develop that data breach response. How do we actually do a quick action, containment first, and impact assessment on how much of information has been lost? And then this is very critical and it's very crucial. That is the reason the timely notification is to be affected. How do we do that is through a consistent training through this particular, and having as necessary roles of data protection officer, data privacy officers within that particular team. And again, this need not be a role, full-time role, but still we need to have a mandated person or a mandated group of people who can actually work on this. Any questions?
In fact, see, in GDPR, even in UK GDPR, we have 72 hours as a turnaround time or as a notification time period to the supervisory authority. Do we have something like that for Australian law, Australian privacy law? The incidence notification timeline. So is there something like, within this many hours you should report it?
Yeah, so it depends on the level of data breach, but definitely if you actually go through the noticeable data breach, which I'll go through the summary slide, definitely we have an SLS for each of the, it depends on the kind of, once the company assesses it, it actually depends on how much of SLA it actually gets categorized. So, and what kind of information got actually like exposed. So depending on that, there are SLAs which needs to be binded. So initial thing response is to first notify the regulatory body. Once they actually like get notified, the regulatory body immediately will put up an action plan with the company, and they'll try to assess what kind of SLA they need to follow and how frequently they need to update their stakeholders. That is what they'll actually like put through. They do have that kind of, yes.
Okay.
Chaitanya, I have a question. So you said there is a Australian body is there. Okay. For example, data is what is that? Data is getting from different multiple countries, right? So in that case, how the multiple international law policy, data policy is applied here? For example, I may get data from US, I may get data from Taiwan, India, etc., etc. In that case, when it comes to a channel, so how it is getting consolidated as a one policy suite to process it, the external data, third party data, like that?
Yeah, that's a good question. So in this particular case, definitely the scenarios would occur. It depends on see, every country is bound by that their customers, where the customer is physically sitting versus where the data is actually getting stored, right? In this case, if the data is, say, for example, you take the example of Taiwan or Singapore, and we actually have the customer sitting here, but the vendor or whoever it is actually located in Taiwan or Singapore, and the data got breached there, still our loss actually like applies there. We need to work with the concerned companies to ensure that that particular the SLAs of regulatory body is actually like followed. So we need to actually, so there is a slide for it, the international data transfer. How do we actually like ensure that we have a APP8, which is what we talk about, international data transfer. But having said that, if the company did not adhere to which is APP0, APP8, which is related to international data transfer, what it means is they have not followed a particular practice to actually like ensure that vendor we don't have a very strict contract engagements with that particular vendor on the customer data, and assume that that vendor got hacked within that country, then loosely we can work to mitigate that, but the damage is already done in that example, what I'm trying to say. So in this case, we need to first ensure that we do have a containment plan, but still the regulatory body will actually like work with that business. There'll be a huge fine to that particular company because they did not actually like really adhere to that particular Australian privacy principle. But then they'll put a like impact assessment, and then they will start putting a kind of a response plan. So, but still, to your question, the answer is we still have that the regulatory body will have a vested interest in that particular conversation as well.
Thank you so much.
Hi, sorry, just need a clarification there. Hi, Chaitanya. So are we saying that if data from multiple countries are collected, the Australian data policy will apply? Is that what we are saying?
See, for example, yes. See, for example, GDPR is there, right? Say we operate in Ireland, for example, and we store customer data within Ireland. So the Ireland strict policy actually says that the data should not should not actually they never said that the data should only sit in Ireland or in Europe. What they said was wherever the data can be taken, you can actually take it. First, you need to get a consent from the customer, and customer should be aware the data is being moved. Number one. Number two, wherever you are taking, you are actually like ensuring that you really follow the GDPR principles, what we actually have on international data transfer. So in this particular case,
from the source country, that you need to ensure that
100%
from the source country that regulation is met.
Yes, because the source country where the customers are actually there, they have to know, that is their right to know that my data is being taken out somewhere. And if my consent is no, I don't want this data to be stored anywhere, then the company has to abide by the customer's consent principle.
Okay. I had another question. One of the previous slides, we saw that the organization should take enough care to maintain the personal information. So, but is it prescriptive? I mean, what I want to ask is, one organization may say that, I just keep my customer data under lock and key. Another organization may say that, okay, I will encrypt the customer data and store it in a secure folder. So there are different ways to do it. So yeah, my question is, does the regulation say how exactly to do it, or does it leave it on the company or the organization to take care of that requirement?
Yeah, this is a good question. Thanks for asking. See, one thing, let me simplify that thing for you. Say, for example, RBI is there in India, the Reserve Bank of India, and we have different banks across India. Like we have government, State Bank of India, then we actually have private banks like ICCI, HDFC, right? Now, RBI will put up the best practices of how banks should actually operate. Okay, RBI will frequently audit the banks, whether their banks are actually really adhering to the particular best practices what RBI set up. But RBI doesn't actually go into day-to-day working of the bank. Likewise, any regulatory body, they would actually publish the best practices. And if your company is handling sensitive data or PI data, see, there's a difference between personal PI data versus sensitive data. Say, for example, you have PI, so name, and then you actually have address, then you have your date of birth. So some data, now sensitive data is your political views, your gender, and then you actually your likes and dislikes. So there is a way to actually, so regulatory bodies, to answer your question, can only put up the best practices, and they do frequent audits. Like, say, for example, I'm a data protection officer in my company, for example. I do conduct DPIs, which are the data protection and impact assessments, and data the privacy impact assessments frequently, to ensure that I'm actually auditing and my company is actually really following the best practices which are laid out by the government. And frequently, if the government or the regulatory body frequently changes it, I will go and actually revise how it will impact my company on dealing with the data. And then I will try to fine tune my training or my security best practices, the protective measures within the company. So in this case, you can't actually any regulatory bodies can't, they can enforce, but they can't really go into every company to see whether they are really the companies are enforcing, unless and until there's a data breach occurred. So that is the reason they put the concept of SLS and fines here, to ensure that the companies actually they can actually see that, oh, my motivation is that I don't want to pay that much huge fine. What it means is that I will try to ensure that I adhere to the best practices. I know that I'm actually handling the sensitive data, and I need to ensure that whatever the APP's principles or the NTPs, which are the plans would actually have. So there is a way to do it. Now the different ways to do it is, how do you ensure that your employees are trained? How do you ensure that your actually protective measures are there? How do you ensure that you can minimize your breach impact when you really have a breach? What are the best practices of the security, data security you can have? So these are, and you do it on a regular basis to ensure, and also you'll invite external auditors into the company to audit this particular thing when you actually have. So in this way, this is a constant exercise, Bhakta. So it is not like a foolproof thing that once you actually do it, we need to evolve on a day-to-day basis, because people outside are also getting smart when they do data breaches as well. So we need to be evolving, and we need to learn from each other on the experience.
So the audits are self-initiated, is it? It's not mandated by any regulation or anything.
See, there is a kind of, nothing is specific to that. For take the example of Australia, you need to do, we do audits every 6 months. Now we have reduced it to every 3 months, because now we have started having 540 stores. We actually have a lot of channels. So we want to ensure that we always get an external auditor to do it. We get KPMG or EY, or we get a kind of a cybersecurity to run penetration testing. So we do a lot of different layers to ensure that we are always internally. Our teams, we don't employ a data protection officer. We don't have a full-time data protection officer, but we do have a data protection officer sitting outside, and sometimes they actually run it without even our notice, to ensure that how prepared we are. So we do mock drills. So in a way, we actually do it ourselves, but there is no mandate that you have, but there is a recommendation that you have to do frequently. but it's not a mandate that you have to do it in June. Then again, you have to do it in December. Again, you have to do it in March. There is no specific mandate like that.
Okay, thanks.
Yeah. All right. I'll move on. So then, how do you develop? See, as we discussed, I think this is the same topic: developing a data breach response plan. How do you ensure that you have the communication and the containment procedures are the key? As I'm just talking about it, how do you ensure that the communication and the content? So, data protection depends on your company's infrastructure. Companies, how robust is your infrastructure and where exactly it is sitting? Is it sitting in the cloud, or is it sitting in on-premise, or is it a kind of an hybrid architecture? Now, most of the legacy companies like us or any companies, big companies, they do have an hybrid structure, infrastructure. So how do you protect in this particular thing? Where does the customer data store? And what is the difference between storing a customer data versus financial records versus some sales transactions? So there's a different ways to do it. And as some one of the unexpected person here said that do we really need to store all the data like encryption with data at encryption at rest? It is not mandated. So you can always store it as long as it's secure. There are different ways to secure the data. So in a way, we can actually do it. That's allowing is fine. So, but here when we're talking about a response plan, it is important that the communication and the person, a company who is going through this data breach, they need to have a nominated person who can really talk to the regulatory authorities. They can talk to the media. They can talk to the other stakeholders to ensure that there's a proper communication. There's a specific role what the persons will play, and what are the containment procedures what we have. So to your point, Bhakta, regular testing and updates, ensuring alignment with the current threats and regulation is the key. So that is what I was actually telling you, that this is very important, that if the companies don't do it by themselves, it is very hard to protect the data because company knows their internal stuff themselves better.
Okay.
So I will, yeah, please.
Yeah. So in modern technologies, right? So what is your recommendations on having data in a private cloud and having data in a service provider's cloud? Because when you're getting into a service provider cloud, so we have to trust the service provider to have all the data protected in their zone. So how far it is? What is the best practice? So better to have cloud in their own private zone, or getting into a public, not a public zone. For example, you have service providers like Azure, GCP is there, and AWS is there. So what is your recommendation on that? Because when you're getting into, please go ahead.
No. See, that's a valid question. We also went through that question, and even we are evolving with that particular answer. See, I'll tell you honestly. I'll tell you about my experience. One of my companies, including our mindset was on premise. So our mindset was, anything on sensitive data, let's not take any chance. Let's put everything into on premise, and we are protected. That's now when we move to Azure, you have your own subscriptions, or you actually go to AWS or GCP, or you actually move to a vendor managed thing. So in this, like a SaaS, whether it's Microsoft or whoever it is, like vendor neutral dependent, it all depends on what are the best practices you actually follow with respect to data security and the principles what we actually recently just discussed. See, for example, if you are an on-premise company, what it means is all your data infrastructure, everything is in on-premise. So you have your physical data center sitting somewhere, and you have your servers sitting there. And now you have a flat structure where your one system gets actually intruded because of lack of employee training. You don't employ that particular thing. Ultimately, you can actually the hacker would actually go into any system, can grab the data, and the same principle we can actually get a data breach. Similarly, if you go to Azure, or if you actually go to kind of an hybrid structure is very tricky because that's where your principles of obvious data security principles, like your identity, how do you manage your identity? How do you ensure that you actually have an RBAC, which is role-based access? How do you ensure that you actually have a very stringent access controls, which is least privilege principle? You follow that. And because it's very hard to follow zero trust policy, because in this particular current world, what we have from the infrastructure perspective, we have a lot of legacy systems which we can't follow. So as it doesn't matter to your question, Balaji, that should we actually like go, which is better? There is no right answer to it. The answer, important answer, what we need to do is, do we have specific people who are actually responsible for that specific work? Say, for example, do you have a very good security team who actually consistently do monitoring and actually learn from what are the current threats and regulations what we have, and then we actually evolve. We try to actually like have our environment ready to align to that particular thing. And then do we really have that kind of a kind of an audit structure available, where be it vendor, be it in your own personal cloud or a private cloud, or it in on-premise, we need the constant work of evolving to that practices what your company is aligned to. So that is the important thing what we need to follow. If you follow ISO 20001, the information security standards, whatever the standards you follow, still that standards has to be applied into your infrastructure. So this is very important. So in a way, there is no right answer. I cannot actually say that Microsoft is better because we are Microsoft based. It all depends on how robust principles or how robust data security aspects you have, how robust is your security in general. So you actually, and how frequently you train your staff. So that is the way you companies need to adapt and need to actually like grow, because there is no way to stop the company to go to cloud because of scalability. Now, say for example, my company, we are actually like we can't stay in on-premise because we are moving global. At the same time, our infrastructure is not scaling to a level where we want our customer to actually have a better user experience. So in order to do that, you have to move to cloud. In order to move to cloud, you need to actually deploy your things in cloud. So then in this case, how do you ensure that you actually protect your data? That is where we are actually like talking to ensure that it's a constant involvement, regular testing is required, and regular audits from external, internal people are required. And then people, we need to have defined roles in your company doing defined jobs. They should be very clear on their roles and responsibilities. And then the important thing is, how do you identify who is actually logging into your systems? Who is actually like how every employee should actually have an identity, every system should have an identity, and how then role-based access may follow the least privilege principle, and ensure that you actually like have encryption and data integration. When you integrate systems, you actually follow the design principle of the data integration. So they're different. It's a layered answer if to your question, to be very honest.
Yeah, so why I raise this question, right? Especially on the media industries. So though we have the private and private data protection, personal data protection policies are there, we are seeing and we are hearing a lot of data leaks and audio leaks by all the politicians. How this is happening, right? So this
No,
is the
Balaji,
biggest challenge.
I'll also add up to what Murthy has actually said to you, Balaji. See, Balaji, one thing is clear. The cloud can actually give you only the availability assurance.
Yeah.
Okay, when it comes to confidentiality and integrity, they just give us the tools and we need to actually take care of it.
Yes.
Now, the biggest question on putting in data on the cloud is on the physical location. That is the only concern. Otherwise, they have the robust of the platform. It's like, the school perimeter can secure all the children. They cannot individually secure each and every child. Okay, maybe on a specialized case, you give a donation and all, they actually do it. The cloud service providers also, they have uptime, tier 4 uptime, right? So it's 99.995% uptime is what they give you. When it comes to encryption and the confidentiality and integrity, they just give us a provision because they don't know what the data that we have actually put on a cloud. Because like the donkey, you 10 kilos of stone and 10 kilos of diamond, it doesn't matter for a donkey. All it is the weight that it can actually pick it up. Now, in case we are more concerned about the physical location of the host in which the virtualized environment is running, we can go for an internal cloud. Okay, internal, obviously, if you're a cloud service provider, it becomes an internal public. But if you're a company which is consuming the services, that becomes internal and private cloud. Now, if you're going to ask me about the question, okay, there are videos that are hosted, it gets leaked. Okay, so NSA has identified one of the top 7 threats for the cloud computing, nefarious use of the cloud services. So the cloud service provider doesn't know what you're actually putting inside, okay, and what you're actually sharing. So they can actually block it only based on a complaint. Otherwise, they don't know what you're actually doing. All they do is, I'll give you the space, I'll ensure the availability. Your data is your data. You want to encrypt, you encrypt. Okay, if you want to implement the protection for the integrity, you actually do it. Okay, so if you, on the ground level, it's only the availability that is actually assured by the CSP. Maybe I'm taking a bit of a long time because we have only 12 more minutes. I'm sorry for this, Murthy. So is that
No, that's all right.
am I answer, I mean, question, Zabalaji?
I agree on that, but I would like to debate on that. So, if that be the case, we have process when data in rest, data in transit, and data in use, where various encryption and decryption techniques are there. So, they are giving confidence to the customers to protect the data in various forms of data in motion, data in rest, data in use, everything, right? If that be the case, why these leaks are happening? So you're telling that you apply your own encryption, then what is the, how come the service providers allow you to apply their own encryption, right? So they
Okay,
have their own encryption. AES 256 is there, AES 258 is there, right? So they're all recommended for the data encryption and protection.
absolutely. Whether you use it or not,
Recommended.
finally,
That's
see, we also
yeah.
train people on penetration testing, right? So when we see, there are a lot of things, okay, but what I had seen is very popular websites are also not secured. Okay, I can in fact read the email and the hash of the password, and the password is not very strong. So we're able to crack the hashes, okay, either with a tool in Kali Linux itself or on the websites. We're able to crack, we're able to log in. And trust me, these are the websites, okay, which are very popular. Okay, now there are provisions. For sure, if you have encrypted your data with AES 256, you cannot decrypt it without knowing a key, because symmetry can, without knowing a key. Even if you want to break it, it takes not less than 40, 50 years to actually break it. And after that, your data itself is not valid. Okay, the useful life of the data itself is actually not there. Now, there is something on security, okay, which is actually called as an, the cover time and work recovery time, okay, or work time. Cover time is how long you want the data to be secured. Okay, and the work time is how long will it take for somebody to break it? Ideally, you should enforce your security or cryptography algorithm and the key length in such a way that somebody is trying to do a brute force on the key. Okay, it takes more than the cover time. So that, for example, if your credit card details are valid, it should be valid for 5 years. And you have to put in the encryption crypto system in such a way that when you're trying to brute force the key, it should take 6 years for you to break it. Okay, so sixth year, your credit card details itself is not valid. Now, implementing security is an art, okay, because which requires a trade-off between the security and the performance. Because the key length is too high, okay, the performance degradation will be there. The customers will start complaining. If the key length is too low, customers are delighted, but security is actually not there. So we need to strike a balance. So it is like,
It's
if it's
yeah.
internal cloud, you're not dependent on the ISP's network. If it's an external cloud, ISP's network is also adding up a latency and there's a risk. Okay,
And
but one thing
yeah.
is internal cloud, you can either go for outsourced support or in-house support. There's something called the Jericho's Cloud Cube, okay, where we actually discuss this. In fact, it's a very good discussion. We can have a separate group discussion
Yeah,
on this
we
particular.
should. Yeah, I think it's a very layered discussion. As it's and there's no right answer to it, Balaji, to be very honest, because it depends on what kind of data you're protecting. At the same time, do you really apply the same rule for all? The answer is no. But we need to actually, like, it's a good debate what we can actually like have. But it all depends on the experience of the person or the people or the companies they actually like want it, and how and what kind of business they are in. If it is like related to only protecting customer data, there are different ways to do it. But if you are actually like earning revenue out of it, like say Amazon or something, then it's different. Say for example, Chemist, we don't earn revenue from customer data because we store it as a part of our regulation because we are retail pharmacy. So in a way, for us, we don't do personalization on customer data because we strict no for it. I'm mainly talking about health data. So in that way, how do you ensure that the customer, for us, the customer data protection is only confined to that. But if you do any personalizations or you use the data for something else, then the protection is different. So there are different ways. Again, we can take it offline, and probably we should actually have another webinar to discuss that.
Yeah, the debate is the closure for the debate is we are insecure in a secured environment.
Yeah, 100%. That's the reason you still have this kind of evolving discussions, and also people are actually ethical hacking became a kind of a subject where you actually have a role because and also like hackers are getting more and more smarter nowadays. So we do have a lot of things, and now because of this, have you seen the NVIDIA's like microprocessor chips? Now the NPUs, neural processing units, what it means is that you can actually break things faster because they can process things faster. So there's a lot of things which actually has its pros and cons. So we need to just go with it, but we need to keep ourselves up to date to ensure that whatever industry you are in, you need to ensure how you can actually like be at least aligned to that, and then how can you apply back to that particular thing. So anyway, I'll just move on.
Yeah.
Yeah.
Sorry,
So yeah, go ahead.
Rangnath here. I just pasted some information question in the chat actually. So
Sure.
the question that regional or country wise we have some data privacy policy, right? So like America and GDPR in Europe and Australia. So even though since cloud data centers it is around the world, right?
Yeah.
Since the person employs a part of a company, so we are going to procure a environment and we are installing or storing a data around the world wherever we based on our company requirement, whatever. So even though how the regional and country wise data protection policies it is taken care in the company wise, still I need to understand in the cloud wise.
See, for example, I'll tell you one of my experience. We are implementing customer data platform, say in our company, for example, right? We do invite vendors. Ultimately, our CDP will host, say, customer data, and then we assume that it will be in Australia. But we are also having customers or vendors who will be actually like or we do have, say, we are working in Dubai and Ireland, so we do have some data sitting in Dubai, for example, and then you actually like have. So it all depends on the requirements of how we actually like gather for that particular program. So, and also understanding GDPR or understanding any of the local principles is not an easy task. For example, when we go to Dubai, for example, we don't really know how Dubai operates or UAE operates from their own data privacy principles. So what we do is we do actually like engage a local privacy practitioner within that particular country who is well versed in that country. We do put requirements and we actually we tell what is that the company wants to achieve within that particular regional thing. And then we try to see how that particular, whatever the requirements we have is aligned to UAE privacy principle laws. I'm just giving a specific example. So then we'll try to actually like try to identify what are the mandatory principles we need to apply and what are the optional things we can actually like relax. So then based on it, we try to act. So there is nothing called global, because global, again, where you see, if it is sensitive data, definitely every country will prefer that the data should be sitting within that country. But having said that, if the customer gives an like consent, then definitely for Australia, they will allow. But in some other countries, they won't actually like allow. So it all depends on the regional requirements. We need to engage the regional practitioners to understand the laws, because it is very hard for a company operating very well in Australia can actually go to some other country and really understand the laws unless until we engage the local partners there. So the regional requirements have to be mandated, and then we need to work with the regional partners to understand the regional laws so that we don't breach the laws, whatever that local government has actually put.
Okay. Got it. Yeah, thank you.
Yeah, Modi, just to also let you know, like, we are nearing the closure time. I think we still have some more slides to cover.
Yeah, we have some slides to cover, but I'll just like quickly skim through because we spoke about cross-border data transfer, which is related to how does the businesses ensure overseas recipients comply. What I will do is, Subbu, just because we are losing time, I will actually like, it's a good discussion. I'll just go to the key slide thing, which actually talks about the key takeaways of what I want to actually like what we discussed so far. So that will actually give you a kind of an overall view of what exactly these slides actually like I've gone through, so that we can close the session there. Yeah.
No, I just have another option for you in case you want to have, because it's actually a very good discussion. Should we have a continuation session tomorrow the same time if you are available?
No problem. I think I can do it probably because I have a yoga session which I need to do 6 to I think it will be finishing off by 10:30. If I'm actually like doing, I can do it after 11 if everyone is okay.
So
Yeah, because we have a DPO training now. So
Yeah,
I was just thinking, okay, so if we can finish it off quickly, we can continue. Otherwise, tomorrow same time we can, because we are comfortable to discuss with the participants, and they also have a lot of queries.
No problem. I'm happy to discuss because this is also learning for me. So if you feel that we can actually like have one more session, everyone, I'm happy to do it tomorrow after 11.
The same time tomorrow is okay?
Can we do it at 11 o'clock?
Do it
11
when,
o'clock
sorry?
you have a session. 11 o'clock? 11 o'clock?
1 o'clock, is it?
No, 11 o'clock.
Well,
11 o'clock.
Murthy, we got a session at 11:30 our time, so yeah, it would be difficult.
Okay. So can we do it at in the afternoon after your session?
After my session will end at 4:30 the Indian time. That'll be too late for you, isn't it?
Okay,
Yeah, it would be
let's
9
do
o'clock.
one. Yeah, let's do one thing. Let's do it at I'll try out. Let's do it at 10 o'clock our time, which is Indian time. Is it okay? 10 o'clock, 10 to 11, same time?
Absolutely fine.
Yeah. Okay. Is everyone okay with that?
Okay, it's fine.
Yeah, not a
Okay,
problem.
then,
Thank you
then-
very much, Murthy.
No problem.
It had, in
No
fact,
problem.
it was beautiful than what we expected. We had a lot of discussions. In fact, HR Ranganatha has something, because Praveen, myself, Praveen had been together for so many years, and I know Balaji and I know Bhakta Das, because they're all a part of my ISSS family, like you, Murthy. In fact, Ranganatha is something which is new to me. Okay, thanks, Ranga, to ask questions.
it's a feedback. It was an excellent session. It's a debatable session. Fantastic. We'd like to continue this type of the interactions.
For sure.
Thank you. Sure.
What we want to have is for the same time tomorrow. Let me send out an invite, and I wholeheartedly request all the participants for this session to also accommodate us for tomorrow. And Murthy is with a rich experience. In fact, I don't want to leave him. Okay, so I want to even learn from him. Okay, so join us for tomorrow, and this particular session is getting recorded anyway. I will have this thing uploaded and send you the link. And tomorrow's session will also be recorded anyway. Okay. So Murthy, just accommodate us for the same time tomorrow.
Sure.
Okay, it's a humble request my end. Okay.
No problem. It's learning for
Thank you
me
very
as
much.
well.
Then.
Thanks
So people, thanks for joining me for today, and I will send you the link for tomorrow. And please join us. Thank you very much.